Has the AG's office experienced a increase in the number of cases being removed to federal court?
Yes, I used to, before I was in my current job, I was the assistant deputy director in charge of our field legal practice for all of our offices around the state, and it is a recurring problem for us when we get these requests to remove cases to federal court. They delay because the court has to stay proceedings until the federal court makes the determination as to whether or not it belongs in federal court or not. So it's a delay tactic. It costs, we have to utilize our general counsel resources, our appellate attorneys to deal with those cases. Sometimes we have to use the resources in other divisions of our agency to help to get those cases, get the proper arguments before the federal courts to get those cases remanded back to the state courts.
What's generally the basis for the removal?
They cite a lot of these had to do with they cite elements of the law that really don't apply to those cases. We call them sovereign. We always call them sovereign citizen cases. That's the terminology we use. And we have a document, and there's about, I think the last time I looked, there was about 25 different arguments they make. And so we developed a document on what our response to each one of those different types of allegations is. And it's usually some obscure part of the law that doesn't apply to the case, the family law case. But the problem is that as soon as they file to remove it, we have to deal with it, and then it delays the case, which delays. A lot of these are enforcement cases where we're trying to enforce the child support order, and that causes delays in our ability to collect the money for the family.
Would it be fair to say that all of these cases that are where an attempt was made to remove it to federal court are sent back to the state court?
I would say almost everyone I've ever seen has been removed.
Are there any that have
been removed back to the state court?
Have been. Are there any that have been stayed in the federal court?
None that I am aware of. It's just a process that we have to go through when we get these, and so I would say it can be a significant detriment to us, particularly on an individual case basis, because it really, the only purpose of it, from my point of view, is that it's just to delay the end result. Is it just delays our ability to resolve the case.
How would you stop that?
That's a good question. I think the Family Law Foundation has been working on some issues with that I'm aware of. So
Joelle Cannon Sheridan, and I'm the president of the Texas Family Law Foundation. So the Texas Family Law Foundation, we kind of call ourselves the lobbying arm of the Texas State Bar Family Law section.
So when it gets moved back to state court, they still owe the child support.
Right, they still owe the child. They actually usually owe more because.
Yeah, I was about to say, that it would be an increase in the amount that they owe.
Right. What
happens then?
Well, at that point, we resume our enforcement of the case, which can include a judgment, a contempt.
Can you also seek the cost of the attempted removal?
We can we can seek attorney's fees, but our attorney's fees policy essentially only allows us to request attorney's fees for the time we spend in the state court prosecuting the case. But that may be a reason on those particular cases that we may exercise our option to request those attorney's fees.
And you have that opportunity to do that right now.
Yes, we have the opportunity to request attorney's fees. I believe it's in cases, and the court's required to provide them or to order them if the person is found in contempt of court and owes over $20,000 in arrears. I think that's still in statute. It was at one point. I think it still is.
Yeah, and that's mandatory.
It's mandatory if we pursue them and make the
Right.
request. Yes.
Right. And so one of the ways you could help decrease the incentive for doing that would be to request attorney's fees for all of the cost that you had to come out of pocket with, so to speak, for the removal attempt.
I think that we could make that an available option if we pursued that. Yes, I think we could make the argument that the court generally I think that the problem may be the court requesting us for attorney's fees in a federal case in a state court, but
Yeah.
I'm certain that many of the judges would entertain that because I think they're frustrated as well.
Right. Well, that's what I wondered, whether or not the state court judge would allow you to do that.
I think some I can't speak for all the judges, but I think some judges might, and some judges might question that.
And so if you had a statute that says the state had a right to do that, then the judges wouldn't be able to ignore that. And then you could make the request for the attorney's fees based around the cost of having to defend the removal in state court, and a state judge would have to consider that.
I believe you're right.
What and just so that we know, typically, what does it cost for you to defend one of these removals?
I don't know that we've ever come up with the costs on that. We could probably run some numbers for you and
Would
see
you
if we
please?
can. Yes.
Because I think what one of the things we might do to discourage it is allow for the collection of the attorney's fees and cost associated with having to defend this removal. If the judge in the federal court makes a finding that it was frivolous or outside the law.
I certainly can see that being a possible deterrent for people to take those actions.
Okay. Yeah.